All right, that was Joseph Profetti of the Chicago Police Department reading one of the reports written by one of these officers who is on trial for covering up the death of Laquan McDonald back in 2014. Joining me here live on set today is Brian Buckmire, New York City Public Defender. Thanks so much for being here, Brian. Now, this trial we know is going to be a little bit different than Van Dyke's trial. That was a trial walking through what happened, when it happened, lots of eyewitness testimony, which we are hearing here too. But, you know, we just heard the last witness read a document. A lot of this is going to be reading through the documents because of police, you know, these officers had to file reports, had to do record keeping. You know, what is sort of the effect of having all of these documents reread?
Well, first of all, thank you for having me here. So the effect is, a lot of this case has to do with the difference between what actually happened or what people perceive happened based on the video and what was documented by the officers. Whenever a police officer has any interactions with a civilian, they have to document the reason why they spoke to them, the reason why they were stopped, what occurred during that action. It could be anywhere from as small as just fill in the blanks or to a full narrative. What you've seen here now is some of the reports that were written by the two defendants who were police officers and then reviewed by the detective, and what they wrote off on, what they said actually occurred and happened. And so, like you said, a lot of it's going to come down to what they documented, which is what the prosecutor believes is the cover-up, and what actually we can see from the video.
Yeah, I mean, and in terms of the defense attorney, the officers and their defense attorneys, I mean, I feel like they could argue, you know, this is what we believed happened, the heat of the moment, we had to file these reports quickly. Will that argument fly?
I don't think so, because especially with Detective March, some of these documents are actually filed well after the incident occurs. And he actually references that he viewed the video, and after viewing the video, that's what he saw. Now, is that his defense? This is the perspective of a detective who has done this for many years, right, and this is what I saw. I think that's probably what he's going with. I believe with Detective Walsh, or Officer Walsh, or the other defendant, Duffney, he might be saying, yes, in the heat of the moment, this is what I perceived. I wrote this one report, and that's what I believe happened, and I'm sticking by that.
Because he was his partner that night on the scene. But yeah, you're right. Detective March, or ex-Detective March, a seasoned homicide detective. We're going to take a quick break. Stay with us. We'll be back with much more on this cop cover-up trial. So there we have Joseph Profetti from the Chicago Police Department reading some more of the reports that were filed after the shooting of Laquan McDonald. And here we hear one of the officers wrote that Laquan McDonald had a knife and was, you know, or as he calls it, a cutting instrument. And so Brian Buckmire is still here with me in studio, public defender here in New York City. You know, the police are saying he had a knife, and in their reports, and they're saying, you know, he was advancing on them. They know that there's going to be video in this situation, right? They know that that camera's rolling, the body camera, the dash cam video. So, you know, why would they perhaps fudge their story a little bit, so to speak, you know, which is what prosecutors are saying that they did?
The simple answer would be history. The reason why this is such a huge landmark case is because this is one of the few convictions that Chicago and a lot of cities in America have gotten a conviction of an officer killing an individual. In the past, where there is video and the police officer's own testimony, courts will typically defer to the officer's testimony, because they do not want to second-guess an officer who's in the heat of the moment, who's there, who feels the threat as they perceive. And the law does allow for both a subjective and an objective view of it. So us, being laypersons who are not officers, we have no idea what it's like to be in a situation where someone is advancing on you with a weapon, with their fists, whatever it may be. So courts, I don't want to give a percentage, but as a phrase, like 9 times out of 10 will side with the officer. So the reason why even we have this video, and you and I can be like, why would you do that? You're being taped. That doesn't make sense.
Right.
For an officer, in their mind, is saying, I've seen it happen in the past. I've seen video that looks kind of weird. My officers will back me up. If I say that I felt this way, the officers in my precinct and the judge will rule.
Right. And this sort of, you know, expectation, I guess, of loyalty to one another, kind of like the brotherhood, you know, between the officers, and yeah, we'll all tell the same story, and let's all get on the same page. Obviously, in this case, it didn't work, and a lot of people saw through it. Let's go back now and hear a little bit more testimony from this time Officer Joseph McElliott of the Chicago Police Department. Well, Officer McElliott also testified in Van Dyke's trial, actually recounting much of the same, which we're hearing from a lot of witnesses. But here on the stand, we heard him say that he felt that his partner was protected, and he really didn't feel like there was any personal risk to himself. He had drawn his weapon, but at that time he was just kind of waiting out the situation because Officer Gaffney had asked for a taser. How does this testimony work against the three officers on trial here?
It does and it doesn't. I think it would work against them much more in a jury trial, because a jury can often conflate, okay, if there are these two officers there and there are additional officers who feel contrary to what they felt, then these two officers must be unreasonable. And that's probably why Van Dyke was convicted, because they were able to mix that. We spoke a little bit about the fact that this is a bench trial.
Right.
I think what they're trying to do is trying to avoid that, because the judge should know that when it comes to the belief of needing to use deadly force, it would be strictly on that one individual cop, and that they shouldn't use the other cop's perspective, experience, and sentiments to say that this person's subjective feelings was wrong.
Yeah, I mean, it is interesting, and a lot of people may not even realize initially watching this that there is no jury. This is all the judge, Judge Domenica Stevenson. Are you surprised that these officers would go that route?
Not at all. I think it's a very intelligent move by the defense attorneys for a number of reasons. If you look at their background, they're all former prosecutors. The judge is actually a former prosecutor, and I'm not trying to say there's any impropriety happening. It's just a strategic move. I think actually the defense attorney for Mr. March, I think at one point in time he was a prosecutor with the judge on a case. And again, not saying there's any impropriety, but I think that when you have that route, you're definitely thinking, okay, the judge is going to separate issues that a jury might not, and I might be able to do better for my client.
You know, it's interesting you mentioned there is, you know, we can't assume that there's impropriety, but, you know, in a case like that, I mean, would they just say from the get-go, look, we work together, you know, maybe there could be a conflict of interest here?
It has to be raised, definitely, and the prosecutor would have to most likely be okay with it and say, you know what, we're fine with this judge presiding over the case. They're probably very confident in their case, and that's why they're allowing it.
Yeah. Okay. Thanks for that, Ben. Stay with us. We're going to take a quick break. We'll be right back after this. Okay, so that was actually testimony from the October trial of Jason Van Dyke. Xavier Torres, who was on the scene testifying about what he saw. So far in the officer cover-up trial, we heard from Xavier's father, and we're going to get to that in a second. But obviously, Ben, still with me here in studio, when you have a live witness at the scene who can give a contradictory account, that will hurt these officers' cases.
Absolutely, because it goes again to two things that the prosecutor's going for. One, that they didn't do a full investigation by speaking to eyewitnesses to try to get the account of what occurred, and two, to show that something different happened than what's in the report. And so when they're doing that, the question is why? And the answer that the prosecutor is suggesting that it's a cover-up, that there's this, as most people refer to as the blue wall of silence, that anyone on their side of the wall is protected, and that they will create documentation and portray that to the police department, to the public, to any other agencies, that what the police officers were there did was justified in their actions.
Let's go ahead now and listen to Xavier's father, Jose Torres, who did testify in this cover-up trial this week. So Jose Torres heard the shots, rather. He saw Laquan McDonald fall to the ground, though he did not actually see the shots fired. Brian Buckmire, New York City public defender, still with me here in studio. Do you think that makes a difference, that he didn't actually see the shots fired? He just kind of saw the aftermath and heard what had happened?
I think it definitely helps the defense, because they're saying that it's a cover-up. And so if he doesn't see what the initial actions are, it's hard for him to say that this was covered up. I think what's important here is not the actual action that occurred, but what the officers did with this potential witness when he was there. It seemed like he was there and was willing to give information, but they kind of shoot him away.
Right. They turned him away. Officers at the scene basically told him to, made hand gestures to move, so he went on in his car. I believe he was going to the hospital with his son. And it was only later when he saw the news, police spokesperson say that Laquan McDonald lunged at Officer Van Dyke when he said to his wife, that kid didn't do that. I saw it. It didn't happen. And he said he couldn't sleep. He couldn't eat. Then he finally called in to not to police, not to the district attorney's office, but to the Office of Independent Police Review Authority. So we're going to hear the cross-examination in just a moment, and defense attorneys are going to say, well, if you were so sure of what you saw, why didn't you call 911? Why didn't you call the prosecutor's office? Well, I mean, valid points, right?
Completely valid, and this is probably the reason why they don't want a jury trial, because again, I'm not from Chicago. I haven't spent a lot of time in Chicago, but the people that I do know who live there, regardless of economic background, what part of Chicago, there are very few people in Chicago who have a pleasant or good feeling towards Chicago police. So if you raise that to a judge, especially a former prosecutor, they would probably have the same question. Why didn't you call 911? Why didn't you do this or that? Most people in Chicago, and even most people in New York, would be like, this is why I don't talk to cops, because I had one bad experience with them, and I'm not going to interact with them when they're in that mode, because I know it might not be pleasant for me. A jury might credit that more than a judge.
How key do you think it was, him coming forward, he and his son coming forward to begin with, in the first trial of Van Dyke? Because they could have just not said anything and gone on with their lives. But how critical do you think it was to have, an independent witness in this case?
I think it's huge. Whenever you have someone testifying, oftentimes either the prosecutor or the defense attorney will have the ability to say, this is an interested witness. They have some stake in the game, and that's why they're coming before you to testify, whether it be the individual who accompanied Laquan, if there was, or the officers who are there. They all have some sort of interest. But here's an individual or two individuals who have no reason to lie, no reason to tell you anything but the absolute truth. And in many cases, independent or uninterested witnesses, their testimony is sometimes held at a higher view for individuals.
All right, thanks, Brian. We're going to take a quick break. When we come back, we'll hear more from Jose Torres as defense attorneys cross-examine him. Stay with us. Seems like they're splitting hairs a little bit here, questioning Jose Torres. Are you sure what you saw on TV? You think it was a police officer, it was actually a spokesperson for the union. I mean, granted now, this is 4 years ago. Does it really matter who he thought was giving the account on TV? Why are they going after that, Brian?
I think you said it perfectly. They're splitting hairs. I think he's digging for something to kind of distinguish between what he saw, what he interpreted, and why he reacted in the way in which he did. I don't really see where the point of this cross-examination is going, distinguishing who the person is who made the report and what was said and what he said to his wife. I would have gone more to the delay, as you alluded to earlier. But here, I just believe they're splitting hairs, and he might be searching for something that he's not quite sure if it's there at all.
Yeah, I mean, and since we have 3 defendants here, 3 separate defense teams, each defense attorney has a chance, of course, to cross-examine each witness. So now let's hear some of the cross-examination from Officer Walsh's attorney. So that was Officer Walsh's attorney cross-examining Jose Torres, one of the 2 civilian witnesses to the Laquan McDonald shooting. So, Brian, is that cross-examination about trying to discredit him because he doesn't remember exactly where the police cars were and which car went by him when? Exactly.
So, and the cross-examination is probably going to be a long one. He's going from the very beginning and probably will follow through all up until what he saw. And he's picking apart what he did see, what he didn't see, what he can remember seeing, and minor details here and there. I think he's eventually going to get to the point where he gets the actual, what he's testifying to see what he saw about Mr. McDonald and say, well, if you weren't sure about this, I'll show you about that. And he'll be able to wrap that up in summation and say, we can discredit this witness because there are details of the events that he doesn't truly remember, and therefore his whole testimony should be considered as such. It's going to be up for the prosecutor to come back there and really hammer through, okay, We understand you don't know where every car stopped and where every piece of hair landed, but when you saw this, what was it?
Going back to the fact that this is a bench trial over a jury trial, do you think that discrediting the witness, trying to discredit witnesses, maybe doesn't work as well with seasoned judges who know these tactics?
Yes and no. From a human aspect, it doesn't work as well because a seasoned judge will be able to, like, I see what you're doing, I understand where you're going with it, but at the same time, you're looking for something, as we say, for the judge to hang their hat on, to say, okay, this was the evidence that came in, I see how this could have discredited this witness, and this is how I'm making my ruling to ensure that it stays, and then if it's ever reviewed by a higher court, they'll say, you know what, this judge came with the right decision because here's the evidence by which this judge made their decision on.
I also want to talk about sort of the unique aspect in this case that we have 3 separate defense teams and how that works. Because first of all, things can get a little bit complicated in the courtroom, and at times you could have attorneys for each client maybe contradicting or going up against each other. Is it a challenge to have 3 separate defense strategies in one courtroom here?
Absolutely. Sometimes the strategies can help each other, sometimes they can hurt. Most times, or at least in New York, if there is an antagonistic defense, they'll be severed. If one officer is saying, hey, this is the bad one who did this, or that's a bad one, and they're antagonistic, then they'll be severed. But it appears for the most part they're not attacking each other. They might be going in the same stream of thought, although from what I've read and understand, they all have different kind of specialized defenses, although they're all kind of moving in the same direction.
Right. Let's talk a little bit about the general defense here. One of the attorneys, March's attorney, said in his opening statement, this case is about law and order. It's about Laquan McDonald not following any laws that night. There has to be some individual responsibility attached to McDonald. Now, in a case about what the officers wrote in their reports or didn't write or say to cover up, do you agree that what Laquan McDonald did or did not do in terms of following laws is important?
I agree insofar as my profession. Maybe me as an individual, a little bit different. But as my profession, I agree and I understand what the defense counsel for Mr. March is doing. He's saying that there are a difference of opinions. That if we got 5 different officers, we might get 2 or 3 different opinions as to how this went. There might be some officer that says too much force. There'd be some officers said just enough force. And if they're going the just enough force route, they're saying this is a criminal, he committed a crime, and this is how we handle it and the way we do it. And that's just his opinion. If your opinion differs, that's fine, but that's not illegal.
Okay, Brian, thanks for that important analysis there. We're going to take another quick break. We will be right back after this. And also coming up in the next hour, new interrogation video of Chris Watts as he confesses to his wife's murder. Stick around. So there it is, the beginning of the interrogation when detectives first sit down with Chris Watts. And basically we hear the lead detective saying, level with us. We know you want to tell us the truth. And he's initially saying, I'm not trying to cover things up. I'm not hiding anything. As we know, his story is about to change. But Brian Buckmire, a defense attorney here in New York with me, I mean, how common is this at the beginning of the interrogation? The defendants, the accused, maybe are confused themselves, don't really know how it's going to go, and their plan is just to keep quiet.
It's very common. You'll see detectives are trained to go through different techniques. They might leave them in the room by themselves for a period of time just to let them sweat it out. I've heard of rooms being left cold or hot to try to make them uncomfortable, and an uncomfortable person will typically give you more information. Sometimes they'll, like you see on TV, good cop, bad cop, flip between the two, try to develop a rapport with the individual to see what they'll say. And they're trained to detect eye contact, pupil dilation, body movement to see, hey, you seem uncomfortable, you're kind of holding yourself, you're kind of leaning to the side. And they might work with someone until they eventually either crack or end up telling the truth like they did in this case. Yeah.
So let's go back to the tape now. We're about to hear Chris Watts say, look, I didn't do anything. I don't know what happened to them. I've got nothing on my hands. Let's take a listen. I love my girls to death, Chris Watts told the detective as he sat there in the interrogation. And she's saying, you've shown no emotion. You haven't shed one tear here in the 2 days you've been here. Help me understand. I don't get it. His demeanor, you know, what do you make of it, Brian?
I see where the detectives are coming from. His demeanor, it doesn't make sense for a father in that situation. If it's him and his wife is missing, then, I mean, I don't have any children. I work with kids, but my first mindset would be like, where are my daughters? Are they safe? Can you help me find them? I'm going to give you all the information to help. If my wife is missing, please at least find my kids. And the female detective there is pretty on point. I'm guessing she's maybe a mother. She's like, hey, like this doesn't add up. What I'm seeing and what I'm hearing doesn't add up. And they're pressing and pressing, and probably that pressure is what eventually causes him to break.
Yeah, I mean, do you ever, you know, you as a defense attorney, you represent all kinds of clients, but you ever wonder, you know, what are these people thinking that they think that they can fool law enforcement, you know, that they won't get caught? I mean, you have to sort of think out your approach, and for him to just kind of sit there and act like nothing happened certainly wasn't helping him.
I mean, usually analogies I go with is often like childhood analogies. I mean, as kids, we think we can get away with almost anything. That if I talk long enough, if I talk about something else, if I move the conversation, it's a pretty natural human reaction when a position or a person of authority is speaking with you. Maybe if I give them a little bit, or maybe if I move in a different direction, I can evade this trouble that I'm in.
Yeah, I mean, he clearly thought that to some extent, and she said, you know, and he said, look, I'm hoping they're somewhere, you know, I'm worried about them, though it's just not that convincing, ultimately. We're going to take a quick break. When we come back, much more from Chris Watts' interrogation. Stay with us. So here we see Watts really starting to break down as he continues to recount this story of seeing his wife, Shanann, smothering their 2 children to death. He says the children were blue, and he says this had happened because she got angry when he brought up separation, potentially ending their marriage. Now, Brian Buckmire, New York City Public Defender, with me here, we were discussing this, you know. When Watts calls his father in the room and starts telling him this story, I mean, we assume he knows that he's on camera. How do you sort of make sense of that he's been telling the detectives up until this point his hands are totally clean, and then his dad comes in and he's like, Dad, here's kind of what really happened?
I think his father being there is a form of catharsis. It's the most interrogations I've seen as a defense attorney, the camera's not hidden. It's not behind a wall or something like that. Usually you can see it, but I don't think this is a time where he's thinking about, I'm being recorded, someone else is going to see this. I think just the weight of what he went through and what he did just got to him. And when he heard that his father was there, that was his time to kind of, let's just release and tell his father what actually happened.
And obviously, okay, this is sort of his first version, or second version, I guess you could say, of the story, where he's saying, you know, I walked up and saw her smothering the children, and starts to break down over this. You know, do you think investigators are immediately suspicious of that account?
Yeah. I think that they're looking for what makes most sense towards a conviction or towards a crime that occurred, which is what their eye is trained for. How did this happen? He's obviously the one where the evidence points the most towards, and they're trying to get him to confess to as many pieces to the puzzle as possible so they can get that conviction that they're looking for.
Yeah. All right, Brian, I know you're sticking around. To our viewers, stick around. We're going to take a quick break. When we come back, much more from this Chris Watts interrogation tape. Cindy Watts in a TV interview to a local station. This was before Chris Watts took the plea, when the death sentence was still on the table. Brian, if you're a defense attorney, would you urge your client's family to go on TV like that while this case is still pending?
Absolutely. Because Cindy Watts plays 2 unique roles. She's not only the mother of my client, but she's also, and I would say more importantly,
she's the grandmother
of the victim. And the mother-in-law of one of the victims as well. So oftentimes when it comes to sentencing, the family of the victims come forward and speak. And I would definitely want her to be speaking in that role when it comes to deciding or giving her input as to what the sentence should be. I would often tell her, hey, talk about as a grandmother, as a mother-in-law, this is what I think is appropriate. I understand, and she's kind of playing some of it out there. I understand that he's remorseful, that if he did it, then he would take responsibility for it. We're just trying to get off of the death. It sounds to me like she did communicate with his defense attorney.
And this was before the sentencing, I guess, when they were talking, when they were presumably negotiating a plea, because the death sentence was on the table. I was just curious for your opinion, because some attorneys might say, look, let's not say anything at this point. Well, we don't know, what's going to happen. But presumably this could have swung some opinion about whether or not he would face the death penalty.
Yeah, it's with most high-profile cases. You know where your jury pool is going to come from. You know that, and this is probably why it was shown in the local news. Right. Because you're expecting that the community that they're going to pick a jury from is going to hear this. Yeah. And if it goes to trial or if it goes to sentencing for the judge, you're trying to get that story out there in a very controlled way where she's not being cross-examined. She's not going to fall apart by a prosecutor's questioning, but you can get out a sympathetic, emotional aspect without that fear of trial.
So in court, Cindy and Ronnie Watts did deliver statements before their son was sentenced. So let's fast forward now to that, to those remarks, their statements that they made on sentencing day. So that was an attorney for Christopher Watts' parents, Cindy and Ronnie, delivering a statement on sentencing day for Chris Watts. Brian, I mean, did they have any choice but to kind of say, apologize for whatever statements they had made previously that maybe seemed to waver a little bit, obviously saying they respect the decision of the court and prosecutors to take the death penalty off the table, do they really have any choice in this? I guess they could have not said anything.
They could have not said anything, but when it comes to trial and sentencing, there are different goals and different standards. When it comes to the trial, you're obviously, as most people perceive, trying to go for the not guilty, trying to show that he didn't do it, it was someone else, as they did. But once that threshold had been crossed, they kind of changed their perspective and changed their goals. Now it's one of more remorse, understanding, and apology. And like as I said before this clip, they took the position of speaking as the parenting laws of the victim as well as the grandparents. So they're kind of stepping in and saying, hey, we are victims here as well because we lost family members as well, and we join them in what they said in part and parcel, but we're here because we're asking for some leniency in regards to this. And they also kind of co-opted that side by saying, if you give him life, he'll be able to give them that remorseful confession that would probably make this community and them at peace.
Yeah, I mean, I was wondering about the confession that they keep referencing there. I mean, have you seen a case like this where they say, okay, after a sentence, the defendant will, at some point in time, deliver a confession?
I haven't seen that, and they're a little bit wrong when it comes to how that works, because if this did go to trial, it would have taken a long time.
Right.
Then if he was given the death penalty, there would have been appeal upon appeal upon appeal. So if you're talking about, hey, give him the opportunity to make this heartfelt apology, it would have definitely been there if he went to trial. It would have definitely been there if he'd appealed. But I understand where they're coming from, where they're kind of falling on the sword and saying he didn't want to put this community and this family through all of this. And so please understand that, and that he will give them the comfort and the solace that they so rightfully deserve.
Yeah. All right. We're going to take a quick break. When we come back, we're going to go back to the interrogation video. Stick around. Well, there, Christopher Watts was giving more details about what he did with the bodies of his wife and his two little girls, Celeste and Bella. It's all rather matter of fact at this point, Brian. I think we still, and granted, we can't, the camera angle we were given by the Frederick Police Department, we don't see Chris's face, but it seems to be a little systematic and matter of fact the way he's talking about how he disposed of his family members' bodies.
Exactly, and this is definitely something that was provided to the defense attorney before taking the plea. And so this goes into the calculus of, do we go to trial, do we not go to trial? And when you see something like this, as most defenders would say, is, okay, so prosecutor, what's the offer? And I think that's probably the right move, because if this gone to trial, and a jury had seen this, and a judge had gotten more details as to how the bodies were disposed of and what the course of conduct was, he was definitely facing the death penalty. So I think that's the right move.
Yeah, I mean, I hate to play off words here, but he essentially dug his own grave in laying this out. Police, of course, found the two girls in oil tanks on the property of this company where he worked, and Shanann was buried in a shallow grave nearby. Well, as we now know, he did take the plea. He pretty much had no choice. The death sentence was off the table, but it was still at the judge's discretion how to sentence him. Let's go ahead and replay the sentencing now.
Yes.
Jose Torres being questioned by the prosecutor about what he saw and heard the night of the shooting. What do you think the prosecutor's strategy is here as she questions him about the details of that night, Brian?
The strategy is to focus on what he saw and how it contradicts what they will later show was in the police officer's police report. To show that there's a narrative outside of what the police officers showed, to show that you have an independent and unbiased witness giving what she being the prosecutor, believes truly happened. And then when you juxtapose it against the police, you show that this was a cover-up. Probably also going to bring in the fact that when he was there, he's shooed away. Again, kind of as part of their cover-up to get rid of any eyewitnesses that can contradict their story.
We heard a few objections there, objections that were sustained. One of the objections happened when he saw, when Mr. Torres said he heard shouting and saw Laquan McDonald turn his head to their direction. What was that objection about, as far as you could ascertain?
So the objection, so when you object, the defense is saying that he is saying something improper. I believe the objection was specifically when he commented past saying he turned his head to the direction of the officers, and he said that's something that anyone would do in that situation. That's objectionable. He can't tell whether or not someone would do that. The other objection, which is a little bit more curious, is when Mr. McDonald's on the ground and he's shot and he's kind of thriving back and forth, and he's saying, well, he's moving back and forth as if he's in pain. The defense attorney objects to it, which I think is kind of proper.
Right. I mean, he doesn't really know if Laquan McDonald was in pain, but, you know, you observe what you observe.
Correct. But most judges will give lay people the ability to describe how someone will react in terms of pain or intoxication, because for the most part, we've either all been in pain or we've all either been intoxicated or seen someone who's intoxicated. So we can, as lay people, kind of be experts in being like, I see that person. I know they're in pain. That's an action that I've done when I'm in pain, or I've seen it enough that other people. So, but that's a judge's determination.
All right. Thanks for explaining that, Brian. Let's go back and hear some more of Mr. Torres' testimony. So Jose Torres talking about the fact that initially he was shooed away from the scene, but when he saw a report on the news the next day in which a police union official was saying that the shooting was justified because Laquan McDonald was lunging at the officer, he said, no, not at all. That's not right. He felt compelled to speak up. Interesting to note, in former Officer Van Dyke's trial earlier this year, Torres, it did not come up. The jury did not know that Torres later came forward to a separate investigative agency to tell him that what he saw did not match up with what police were saying. Obviously, in this case, it is very relevant, though, the part of the story that he later comes forward and says it's eating him up inside and he can't sleep at night. He's got to tell someone what he really saw.
Correct. This is big when it comes to a cover-up story, because for a number of reasons. One, his story is contradicting that what the police officers reported. Two, you might be able to paint the picture that there's a reason why he was shooed away, and that's so that they can limit the amount of witness testimony, which the prosecutor is actually arguing they did. They didn't do a full investigation in the case. When it comes to the prosecution of former Officer Van Dyke, that might be a little bit harder to bring up. There might be what's called a motion in limine, limiting some of the information that might come at trial. So it might have been known by the prosecutor, the defense attorney, but I think that'd be a lot harder to bring in at trial.
Yeah. In terms of, and again, this isn't, you know, I would think that this is something that might sway a jury for Torres to say, it was eating me up inside, I couldn't sleep at night, I had to come forward. I mean, how does this play to a judge, do you think? Similarly? Similarly,
but maybe not to the same extent. Judges are supposed to be more calculated than your average juror. But at the end of the day, every judge is a person. And so not knowing their own personal idiosyncrasies, this could be huge for a judge. Because maybe they've sat on multiple panels where delayed reporting was big for them. Maybe in their own personal experience they've seen this or they felt it, so that could be big for them. Or maybe in their own personal experience it has nothing to do with the case. So again, it's hit or miss, and again, that's very smart by the defense attorney, especially Mr. Marches, who worked with this judge. Maybe he is making this calculation and being like, this might not sway her. So maybe that's why I'm going bench instead of jury.
Yeah. Well, we're going to take a quick break. When we come back, we're going to have much more on this cop cover-up trial. We will continue to hear from Jose Torres. Be right back. So the defense attorney really questioning Jose Torres' account about what he saw the next day and did he see the right person and you know, whether he really knew what he was looking at. You know, we mentioned this a little bit earlier, but is this about discrediting the witness? Is, you know, splitting hairs? You know, why go after this line of questioning about, well, you thought you saw a police officer, but it was actually the police union spokesperson? Yeah,
so you're going after the most minute detail to show that there's a discrepancy between reality and this person's perspective, especially for the defense attorney for Mr. March. I think a lot of his argument is this is the perspective of a seasoned former homicide detective, and there can be reasonable people who have differing opinions, but this is what he saw, this is what he wrote, and this is not a conspiracy. You're attacking this individual based on that. Now, the tone and the demeanor of the defense attorney, it could be any number of things. That could just be his personality, just because the way he comes across. The other thing is you got to remember, this defense attorney is quote unquote like married to this case. He's probably seen a lot of it. He's seen the defendant for a long time, and he might get into the place where he's like, this is truly an injustice, and he might truly believe that. This is an injustice, this person should not be here, and that's the tone that you're hearing. The other thing is you've got to remember, sometimes lawyers are actors. And we put on this show, quote-unquote show, to show both the judge and the jury that I believe that this is an injustice. I'm showing you this is an injustice, and I want you to believe it as well. It's interesting sometimes. You always feel like often your attorneys are actors, right? You've got to deliver the opening statements, the closing statements. You've got to bring drama to it. There's a lot of acting there. Well, I say sometimes just in case there's any prosecutors watching this and know the way I practice. All right, let's continue now with some more cross-examination of Jose Torres. All right, Brian, you're giving the defense attorney high marks on that cross-examination. Yeah, so what you're seeing here is impeachment. Obviously, this witness had testified in the past, and what he's doing is he's going back to the point that the fact that he testified under oath, swore to tell the truth, the whole truth, nothing but the truth, and he gave slightly contradictory testimony. Now, the witness is trying to wiggle out, and somewhat unsuccessfully, because eventually he kind of gives in, especially when you see that point where he's asking, did he try to escape? Right. Did he escape? I'm going to ask you again. And he's saying, no, I'm saying that he walked away. And he's asking the question again and again. At this point, the prosecutor should be jumping up and down saying, objection, asked, answered. You asked the question, he gave you an answer. He didn't describe it as escape, but you see him slowly but surely move into like, all right, finally, if you want to call it that, I'll say he escaped. And the defense attorney is going to take that later on and say, hey, you heard him. He said he was trying to get up. He said he was trying to escape. Right. And these are reasons why officers shoot people, because, and that's justified in the law. Well, you have a point there. He did do a good job in that sense. We're going to take another quick break, but stay with us. When we come back, much more on this trial and others. Stay with us. So the defense attorney asking him about the previous trial, Jason Van Dyke's trial, in which he apparently watched his son Xavier's testimony before he took the stand, but he says he wasn't told not to. So it's almost like a moot point, in my mind, for the attorney going after him on this. Do you agree, Brian? It's a moot point in the sense that he did something wrong, but they can still raise it up to say that the veracity of his claims might be sculpted by what he heard his son say. So it's funny. They're trying to make it seem like the uninterested witnesses are conspiring to get the officers who are conspiring to protect the officer Van Dyke. I think they're going after his credibility as well as the veracity of his story based on this. So his son Xavier, as we said, of course, testified in the first trial about what he saw, and when trial resumes next week, we expect he will be testifying again. We want to go back to the first trial, to Officer Van Dyke's trial, and listen to Xavier's testimony then.
So this is the other civilian account. This is Xavier Torres, Jose's son. This is him testifying at the first trial of Officer Van Dyke's trial. Brian, do you expect we'll hear pretty much of the same when he takes the stand again next week?
Pretty much. I expect him to say something similar, if not exactly the same. And you'll probably get the same thing from the defense attorneys as they did with his father, taking his prior testimony, comparing it to his current testimony and trying to poke holes in it.
Yeah, I mean, it's interesting because we know that Jose testified that he, felt compelled to come forward and talk about what he saw. But in a profile piece written in the Chicago Tribune by the father and son after the fact, Xavier said, you know what, he wasn't sure he wanted to come forward. He has a young daughter. He was worried about what would happen if they went public with what he saw. But ultimately, he said, he decided to stand behind his dad. He always, believes in what he does. He said, we talked about it. We were worried there could be threats, things could go wrong, but ultimately, you have to do the right thing and follow your heart. Do you think the prosecution will sort of follow that line of questioning to get that part out of him?
I think they will, to try to combat what the defense attorneys are already attempting to do, to like, why did you wait so long? Why did you do this? When something compels you, it builds over time. And I mean, that's the nature of it. I'm compelled to walk down the street. I'm compelled to do X, Y, and Z. When you first start off, you might not want to do it, but whether it be guilt or necessity, whatever it is that pushes you to the end result, it takes time. And I think the prosecutor should get in front of it before the defense attorney does. We talked about this briefly before. Obviously, there is the dash cam footage in this case, which contradicted what the officers said happened that night. But we also have Jose and Xavier. With them, would the prosecution's case be as strong, both in the murder trial against Van Dyke and in this cover-up trial? I think it will be. I think it adds another layer that the camera and different vantage points provide a single story. I believe that when the officers testify on their own and the dash cam is there, kind of testifying on this one as well, you only have two vantage points. When you have a third vantage point, you say, okay, here's a third impartial vantage point, and see it's more congruent with the dash cam than it is with the officers. I think that only bolsters the prosecution's case. Yeah,
I mean, it seems like it was very key, and in this case, at least, they were in the right place at the right time, so that there were some witnesses. We're going to take a quick break. When we come back, we are going to continue talking about the cop cover-up trial, and we're going to talk about the emails that came up in court yesterday, why there is some controversy over whether or not they can be introduced into evidence. Stay with us. Brian, I want to thank you so much for sticking with me this whole afternoon. Your insight has been extremely helpful, so we do thank you for being here. In the meantime, I am going to be signing off, but stick around because Judge Ashley Wilcott is coming up next. She will carry the coverage for the rest of the afternoon as we continue to talk about the cop cover-up case and the Chris Watts interrogation. Stick around. We'll be right back here on the Law&Crime Trial Network.